Thank you so much, Layla, also by allowing us to present this, which is very much what we consider like an emerging topic, as something to explore. So really excited to present this incredible tool we have to steward our natural resources. And next slide, Katie, please. A little bit of our conversation roadmap. Want to emphasize conversation because this isn't, we're not here to give solutions, but really present ideas and hopefully start a dialogue with you all, interest you all. On the public trust doctrine, what it is, I don't want to assume everybody's like intimately familiar with our public trust doctrine, so we'll have some of that. And I'm so grateful that Katie's going to be here because she's dedicating like her second year seminar to energy sources as part of the public trust. So she's going to be giving this really great analysis of it. And then again, some ideas, just throwing out what it could look like in actualizing the public trust. And hopefully you guys have some questions, if not now, later. And again, we can continue the dialogue on this. So go ahead and go to the next one. So we can introduce ourselves. So aloha, everyone, again. If we haven't met in person or been at a Hui together, I'm Lauren Ballesteros-Watanabe. I'm an indigenous Chicana mama from East LA, if you're not familiar, but has historic roots there. Both my grandparents are born and raised there in that area. I got a lot of my storytelling beginning then. I always like to say the disclaimer, I'm not an expert in anything except people and being interested in like justice-centered work. And that started at UH Manoa. I've been with Sierra Club since 2019 when I started working with Oahu group, because we do have representation on most islands, working on policy actually. And so I'm a storyteller, I'm a filmmaker, and I'm an organizer. So I like to use my work for that. And why I'm so passionate about energy justice is because knowing about how our historical energy system has been created and it's like legacy of environmental racism, I look at my home much differently. So that little picture is like little frackers as just one example of the many of I grew up with that I didn't really understand until now. And so that's why I think I'm really passionate about changing these things and seeing the transition as an opportunity to do that. And I'll make space for Katie to share a little bit about herself too.
Hi, everyone. Thank you so much, Lauren. And I'm really excited to be here and to speak to you guys and to share about my paper topic that I'm writing about this semester. I'm a second year law student at Richardson School of Law. So that's a graduate program at UH Manoa. I feel very blessed to be living in Kailua. I'm originally from a really small town in Loyalton called Loyalton. I call it near Lake Tahoe, California, because that's like the base that I feel like most people would be familiar with. And I was lucky enough to meet my partner while studying environmental policy at Marist College, and he is my tie to Hawaii. And so I'm currently in law school with him, and feel very grateful for that as well. So my tie to energy justice starts, I feel like, from being from such a small town, and then moving and realizing that there was so much more out there that I wasn't understanding, and being in undergraduate and going to high school in a place where environmental um, law and policy was so important, really played a role in my decision to come to Richardson. And I look forward to pursuing all sorts of environmental justice matters in the future. So thank you guys again for having me.
Yes, yeah, and Sierra Club works all the time with Richardson lawyers. They are badasses in their own right, and I will say that. So what I wanted to do now is just do a very quick recap. We had a really amazing presentation last time with Professor Wallsgrove on restorative energy justice. And so really the goal too of this presentation is how can the public trust be used as a tool of restorative justice? And so I have this very a big mouthful from his white paper on restorative energy justice and the importance of really listening and having the uncomfortable conversations or the uncomfortable act of listening to ideas that don't reinforce the status quo. Like, I love that. I think that's what we're trying to do in this Hui in very many ways or in our own work. For sure, and to kind of recognize, as he laid out in the last presentation, that the unjust and legal theft of political sovereignty from the Hawaiian people is reflected in so many facets of our modern life. We confront it all the time in a very, you know, illegally occupied space. And it's in our energy policy. So that's important. And I think as he talks in his paper, you know, energy justice is underdeveloped. It's relatively recent. But restorative energy justice, even more so, even more so. But it is imperative. And he mentions Kapua Ala-Sproat, who's also a legal scholar at Richardson. And again, the importance of restorative justice for Indigenous peoples is not simply about recognizing harm suffered or like unequal treatment, but really meaning then we need equal treatment. It's rather addressing the loss of land, culture, health, and self-governance for Hawaiian people, right? So justice is not so much about, again, equality, but restoration. And again, hoping we can really uplift the public trust as an opportunity to do so. So these are conversations and truths that aren't always easy, but I really invite you all to really put on like your radical imagination cap and whatnot, because as I look at the public trust, and it's been talked about and mentioned, but definitely not explored as, again, a tool to do this. And I think we're all here because we have the hearts to make it better. So just want to say that there. You can go to the next slide. So just in case, folks, like I said, I don't want to assume people are familiar with the trust doctrine in Article 11, but placing it here so that we all see that energy sources are included as a public trust resource in plain language. And so what's so important about that is because we're finding tensions in our energy transition between our natural resources. I have a photo of the AES West Kauai Hydro Solar project that was paused for some time because of the water diversions associated with the project, because, you know, it was pumped hydro with this large solar farm. And the big issue was there wasn't a full EIS done, which environmental impact statements are another tool that are used to give communities voices to raise concerns, ask questions on the impacts of projects. So why we need to continue to do this work is, as Katie will share and as we'll share, is like the importance of like communities' voices in planning and implementing these projects. So really, really have it in front of you. We're going to talk about it more. You can go to the next one. So again, just a little bit of history, scratching the surface here because there is a lot, but what makes Hawaii's public trust doctrine unique is that it's rooted in Hawaiian worldview. You know, there's trust doctrines throughout the United States. You know, federal courts, state courts use it to protect resources. But again, what's unique for ours is that early kingdom laws recognize that although there were management systems of hierarchy, there was no private ownership the way we think of it in the Western sense, right? Everything was always held as a shared resource for present and future generations, hence why our trust doctrine has that same language. And so one example is the Konohiki system, where Ahupua'a based and ali'is and chiefs would delegate to these Konohikis that their role and authority was directly correlated to their duty to or right per se to control water, to assist and to share, give equitable access to the maka'ainana, which is the tenants of an ahupua'a or the commoners. And so in this respect, like early Hawaiians, again, didn't base their property and legal rights as ownership, but as a shared good. And that is just such a critical aspect because it's of course, something that we want to continue moving forward, that no one should own water, just like no one should own the sun. No one right? It's a different type of value there. And something that Kapua Sprott says is that, for thousands of years, Hawaiian custom and tradition just did these things, right? It was a part of who they were. But once it was written down, then hence we have this kind of way that the kingdom declared that the land and all belonged. Oh, sorry. It's written here in the Constitution, but its resources belong to the chiefs and people in common. So always about stewardship, always about sharing with others. So with the Kanawai of 1839, which created a constitutional monarchy and kind of transformed Hawaii, and as well as the Constitution, it still embedded this idea of like common goods. And so though these things have mixed reviews, right? Because it's about westernizing something that has been tradition. I take from Dr. Kamana Beamer, who kind of in his book, No Makau Kamana, Liberating the Nation, he says, upon the completion of these things, it created this hybrid government that was innovative for the times. And in a way, my hope is that we can work to utilize these resources rooted in this knowledge and values for the energy transition. Like that's why I'm hoping, the Hawaiian worldview, the knowledge and values can be carried over in the work we want to continue today. And so that's my spiel on that as a starting point, and I'll let Katie take it over with really digging more into the trust doctrine.
All right, so I'm going to start off with the public trust tenets, and I will try not to go too deep into the weeds, as this is what I'm getting deep into right now with writing my paper. But for the tenets, the Hawaii Public Trust Doctrine has been expanded on a case-by-case basis, and so that was the way that it was determined that it would be the most beneficial to allow for flexibility. And so currently in the plain language, as Lauren said, it protects all natural resources, and then some are listed. And so that the majority of the case law around the protection and preservation has been around water resources. That has been the majority of the case law, and we'll go into that in a little more detail into which cases decided that. And that is where the focus on the traditional and customary Native Hawaiian rights came into as a protective purpose of the water resources. That was very crucial in determining for the water resources and like water use allocation in the streams, as well as the exploration and expansion of the public trust tenants. And so it was used in the TMT cases and application to land, and it has been cited in other instances with recognition to Hawaii's natural beauty or aesthetic value is sometimes in other public trust doctrines. And so that one's not thoroughly expanded upon in the case law, but it is mentioned, as well as the preservation of a life-sustaining climate that is also mentioned as a public trust tenet, but hasn't been thoroughly expanded upon. And so with these public trust, the natural resources that are protected under the public trust doctrine, there is the obligation of the state and the state agencies to consider public use over private use of resources. And that's been dictated by case law, and that has been set as precedent. And so any time that an agency or any applicant is looking to use a resource, they have to, a natural resource that's protected by the public trust doctrine, they have to demonstrate the maximum reasonable beneficial use. And that can look different for different agencies. A lot of it is as the protections have been assigned, it is on a case-by-case basis. And so that, again, is the most, there's the most case law surrounding that regarding water resources. And so a beneficial use can also be determined to be just maintaining that water body in its natural state. And so that can also be determined to be the maximum reasonable beneficial use. That just has to be demonstrated. And so a lot of the public trust is ultimately a balance between the protection of resources and also the development or the utilization of those resources for the benefit of the people. And so I'll kind of go into more of the historical context now. And the public trust doctrine was ultimately discussed at the 1978 Constitutional Convention, and then it was written into law. And so that's when it became Article 11, Section 1. At this CONCON also established the Office of Hawaiian Affairs, Cultural Preservation, Olelo Hawaii, and as the official state language. And so this was a huge convention. It was massive. They talked about so much. It was very crucial. There was so many big thinkers in the room and so much thought that went into the way that these provisions were going to be crafted to be the most beneficial for people in the future. And so this constitutional convention was where they discussed the inclusion of energy sources. And ultimately, at the CONCON, I'll read a little quote. It was concluded that the promotion of energy conservation, the development of clean, renewable sources of energy, and the achievement of increased energy self-sufficiency would be adequately covered by the provisions of this section, referring to the Public Trust Doctrine section. And so, although this time, we have a lot of changes have happened since 1978, and so there have been reasons to establish more state offices regarding energy and energy policy. But ultimately, the framers of this provision, their intentions were that the public trust doctrine would cover energy sources. And so I argue in my paper, and I hope that you will take into consideration now that that is important, that their intentions do matter. And so ultimately, the public trust doctrine matters in terms of that it really did codify resource management protection as well as Native Hawaiian rights, in that they had to be considered as the traditional and customary rights with regarding the resources. But ultimately, what happened to those energy sources? Were they considered in the long run? And we've kind of given it away naturally, but they, as much as they're included in the plain language, they have not had their time to shine in the case law. And so I'll kind of go over now some of the key cases. Some of these, they're the official case names aren't included. I've just included just the snippets of that. But these are the main cases that I find really tell the story of energy sources and how they can be adapted to be included in the public trust doctrine, just as a potential idea, not looking into anything. Like Lauren said at the beginning, not looking into any answers, just as a potential and whether or not the case law supports that. And so the Waihole decision, that was the huge decision regarding water resources, and that one was based in Oahu, and it really set the tone for that balancing of protection and development. And then the Kauai Springs case was also a water case, but it was on Kauai, and this really solidified the public trust framework and introduced the four protected water purposes. And so that is really where those Native Hawaiian traditional and customary rights come in, are those four protected water purposes. And then TMT2 in 2018, this was the second time the Mauna Kea case went up. That was where the court applied public trust obligations to conservation land. And so previously, there wasn't an application of the public trust doctrine to land resources. And so that case kind of opened the door for the application to land resources. And then in 2022, we had the MECO case, and that was the big heavy hitter with regarding energy sources, but it still doesn't explicitly mention that energy sources are protected. The holding in that case that was very critical is that the PUC has public trust obligations, but that that doesn't really hold a lot of teeth regarding what resources are protected under that. And then the Helco case is where in the concurrence, so not in the majority opinion, it's applied the public trust doctrine to the climate system. So we can kind of see through this like timeline, and it's a condensed timeline. There's a lot, huge expanse of public trust cases. But I felt like these five really encapsulated the idea of how energy sources can be included in the way that we consider the public trust and the relationship that the public trust agencies have with the beneficiaries. And so now I will move into how for the restorative justice.
Hold on, if I may, I just want to give you guys a time. Like you guys have about a little more than 5 minutes, so just want to
Oh,
make sure
understood. Absolutely.
Okay.
All right. So for the restorative justice aspect, ultimately, as Lauren said, there's been the legacy of the energy system being tied to the serious mismanagement of systematic injustices regarding where energy site projects have been cited. And so ultimately, there's a couple that have been listed here, but one of the biggest tenets is that no beneficiary should be disproportionately benefited nor harmed, and that balanced use is the goal. And so really, what I argue in my paper and what I would like to present and hopefully have some interest in is more adoption of a public trust mindset and what it means to be a beneficiary and a trustee. So the public trust, the public trust has the state and the state agencies as the trustee, and then natural resources are in the trust, and the people are the beneficiaries. And so communities are the beneficiaries, and state employees are the trustees. And so I really think that one aspect of incorporating the public trust more would be to use that language for framing some of the ways that we think about energy sources and the way that the state manages them.
Okay, you want me to just share a little bit, Katie, with the 2 minutes we have left? Or did you have this? Go ahead.
Do you wanna go quick or?
Oh no, you share my son's phone.
Okay. So for modern application and challenges, some of the challenges that I will just quickly note that I see is the enforcement of public trust duties with state agencies. And so I ultimately feel that the public trust doctrine with restorative justice has the ability to enhance the accountability of the government to the people. And so in that the relationship between the people as beneficiaries and the government as trustee regarding the assets that are in the trust, which is all natural resources, that should really be strengthened, and that there is the ability to restore a trust that's been systematically broken down over long periods of time with regards to inequities in the system.
Yeah, and I guess we can just be closing thoughts then, Layla. But hopefully there's a part two or continuing discussion. So there are other models we can look at with like trust initiated agencies or have the essence or intentions of the trust. You can go to the next one, Katie. I specifically was thinking at CWIRM, the Commission on Water Resource Management, and how it upholds the state water code, probably has the most teeth in this regard of influencing decision making and having transparency, which is so important, and kind of democratizing how decisions are made because people can provide input on really big, important decisions on how water is allocated. You can go to the next one. And so, again, with the Hawaiian worldview, that knowledge, if we can think of like Ahupua'a resource management, I love this map of how water is looked at through the Ahupua'a system with yields of like maximums and what if energy had minimum and maximums? Because the big thing in our inequity in our system is that you have a few communities, bearing the burden of energy production. And so that is related to the idea of sacrifice zones and climate justice and energy justice. And we don't want to do that moving forward, right? So how could we create something like that? Again, that trust doctrine saying no one should disproportionately benefit or be harmed by our natural resources or energy sources. Next one, or like last one. And we've all seen this and you guys will see it later. Just leaving you all with, again, this like kind of overview of legal scholar Julian Aguon, also out of Richardson. This is really a time to reimagine stretcher thinking because we know we don't want to just reform systems that have been doing so much harm. We really need to like overhaul and make these changes that starts in little and big places. Public trust isn't a silver bullet, but it is an incredible tool as has been shared. So I invite you guys again to really think about it, learn more about it. Thank you, Katie, so much. You can have your closing thoughts, but again, thank you, Layla, for this opportunity.
Thank you all so much. I really appreciate it.
Okay. Yay. Thank you.